Dear colleagues and speakers, the time has come. So I think we can open our event. First of all, I would like to introduce myself. My name is Sava Kuzmenko, and I am the director of the Higher School of Advocacy of Ukrainian National Bar Association. On behalf of Ukrainian lawyers, allow me to thank our partner, the International Bar Association, for helping and organizing today's event. On behalf of the Ukrainian people, allow me to thank you, every person who helped us in such difficult times for Ukraine. I promised Mark Ellis, the Executive Director of International Bar Association, that my opening statement would not last more than 90 seconds. So I will turn it over to our distinguished moderator for today's event, Mark Ellis. Mark, the floor is yours.
Thank you, Sava, and welcome to everyone that is here with us. This is a special time for us at the IBA to be able to reach out and to engage with our Ukrainian colleagues during this exceedingly difficult time. The IBA has been there from the start of Russia's war against Ukraine, and we will continue to be there in support. But this one, this seminar that we're about to undertake is, again, very important for us because we expect this to be the first of a series of seminars focused on international law. And the second seminar will take place already next week, and that's going to be on the general concept of international criminal law. But as you know, this first seminar is on defense issues. And so I think the focus undoubtedly on defense will bring some thought of controversy for at least for some as to why we're doing this. Why are we focusing on the defense? But we have felt very strongly that by undertaking domestic war crime trials that Ukraine is doing now, they have to be consistent with international standards of fairness and impartiality. That this is paramount for actually the credibility of Ukraine. And of course, one of the most essential components of fair trials is effective defense. And I recall, I think it's probably 30 years ago, probably a little longer, when I first met Richard Goldstone, who had just been appointed the prosecutor for the newly formed International Criminal Tribunal for Yugoslavia. And he was also the prosecutor for similar tribunal for Rwanda. But at that time, the Tribunal for Yugoslavia was undertaking its first case, the Tadic case. And this would be the first case of its kind since Nuremberg. And so the entire international community was watching this case. And I met him because I was representing the American Bar Association to see how we could assist him and the court. And after an hour's meeting, he turned to me and said, "Mark, I accept your offer, but with one caveat. I want you to help the defense." And he said he believed that the yardstick measurement of this trial would not be whether Mr. Tadic is found guilty, but he said it's whether Mr. Tadic is perceived to have had a fair trial. And mind you, these are the words of the prosecutor. And so we went forward, we assisted in the defense, and the defense worked with the defense team. And to this day, there has never been a criticism about the fairness of the Tadic trial. So the credibility of the process is absolutely crucial. And Ukraine's ability to show that and show the world that it is able to conduct domestic war crimes tribunals consistent with international standards of fairness will be part of Ukraine's permanent legacy. And that's why we're focusing on this first seminar. I want to thank the IBA experts who are joining us. You have their resumes, so I'm not going to repeat their impressive backgrounds, but as you see, they are extraordinary people and have an extraordinary background in this area of defense on international criminal law area and domestic as well. We want this to be a really interactive session, so please use the chat room to send in questions, and I will, as moderator, try to get them to the appropriate panelists. But this is really your seminar, and we're here to help facilitate it. So now I want to recognize Dr. Valentin Golsty, who's Vice President, as all of you know, of the Ukrainian National Bar Association. And I just want to say to Valentin, I've gotten to know him over the last 7 months, and I find him to be just a remarkable person, an extraordinary leader, and compassionate, and most importantly, he's become a good friend. So Valentin, thank you for your leadership in making this happen, and I'm going to turn it over to you now.
Дякую, Марк. Шановний Марк, шановні спікери, шановні колеги. Я хотів би розпочати сьогодні свою промову зі слів вдячності IBA за організацію спільно з НАУ цього семінару. Цей семінар сьогодні присвячено наданню адвокатам необхідних інструментів, знань та ознайомлення з міжнародним правом пов'язаним із передбачуваними жорстокими злочинами. З 24 лютого 2022 року російські війська завдають
Пане Олександре,
ударів.
перемкніться, будь ласка, на український канал.
Ми маємо невеличку проблему з перекладачем. Треба перемкнутися на український канал. Дякую. Тож, з 24 лютого, як ми всі знаємо, російські війська завдають ударів з авіації та артилерії по містах України, вбиваючи та поранюючи тисячі мирних жителів. Російське вторгнення в Україну безсумнівно є явним порушенням статуту ООН, є злочином агресії, який є незаконним згідно з міжнародним правом. Правові товариства світу повинні співпрацювати між собою, щоб забезпечити ефективне, неупереджене правосуддя за злочини, що скоюються в Україні. Женевські конвенції та додаткові протоколи до них вимагають, щоб будь-які військовополонені, які постали перед судом, мали право на справедливий суд. Ми всі розуміємо, що захист у кримінальних справах буде важким, але уявіть собі, як важко захищати буде нам всім людей, звинувачених у військових злочинах в Україні. Ці справи будуть надзвичайно складними, однак, згідно нашої Конституції, кожна людина має право на захист. І насправді всі, хто вчинили злочини, повинні понести покарання згідно з законодавством України. Дійсно, адвокати повинні володіти видатними навичками та талантами, та повинні бути готові до великого соціального невдоволення та звинувачень з боку суспільства. Тим не менш, ми з вами повинні пам'ятати, що ми відіграємо роль захисників своїх клієнтів і майбутнього міжнародного правосуддя. Цей навчальний модуль має надати адвокатам необхідні знання для розуміння важливості адекватного захисту в міжнародному кримінальному процесі. Це також допоможе адвокатам зрозуміти різноманіття тих завдань, з якими ми зіштовхуємося, і підготує нас до правових і моральних проблем, неминучих у міжнародних трибуналах і судах. Ми визнаємо, що IBA має значний досвід і унікальне розуміння того, що потрібно під час судових процесів для захисту осіб, звинувачених у вчиненні національних військових злочинів. Ми раді, що IBA забезпечить навчання для українських адвокатів з цього приводу. Крім того, також вітається додаткова підтримка IBA, яка пов'язана з важливими питаннями, піднятими IBA щодо забезпечення того, щоб громадськість розуміла життєво важливу роль, яку відіграє професія адвоката в забезпеченні будь-кого обвинуваченого в жорстоких злочинах. Ми з нетерпінням чекаємо на матеріалізацію подальшої співпраці IBA та НАУ, яка обговорювалася. Дуже дякую і бажаю вам цікавого заходу.
Valentin, thank you so much for those words and to reinforce the importance of defense issues. And as I said earlier, for the credibility of Ukraine and what it's going through. We're now going to kind of move forward with a series of discussions on what we think are some of the real key substantive areas for defense, on defense issues. And I'm going to ask David Tolbert to kind of open up our discussions with some remarks and as we then move into these substantive issues that all of you have now in front of you. So David?
Okay, Mark, the translation did not come through, so I'm sure what you were saying.
It's all right, and actually for our IBA panelists, when you put when you're putting the translation, put it on the Ukrainian, and you'll hear the English, so you can switch either side.
Okay. Did you give me some sort of introduction, or should I just not?
I think you can start into it, David.
Okay.
On your few minutes of remarks. Thanks.
Yeah, I just first of all, it's an honor to be with you, and many thanks to Mark and the IBA and our colleagues in Ukraine. There are many things to discuss, but I thought I would, and unfortunately I've been to Ukraine once or twice in the old days with ABA Sealy, but I thought it might be useful to talk about one or two subjects. One is the protection of witnesses and the engagement of victims. I may have been introduced as a deputy prosecutor, but I spend a lot of my time both in the Yugoslavia Tribunal, the Lebanon Tribunal, and the extraordinary chambers in Cambodia. And I think the protection of victims and witnesses is essential for fair trials. There's important and quite a legacy of the protection of witnesses and victims. Without witnesses and without the participation of victims, there is no trial. So to ensure the proceedings, it's critical that witnesses and victims are able to participate without fear and with protection. At the Yugoslavia Tribunal and then many of the other international courts, a special section for the protection of victims and witnesses have been established. One of the key elements of that is the possibility of relocation for protection purposes. Now, in an international court, you can place witnesses and victims in many other many countries across the world that may not be possible in Ukraine, but relocation within the country may provide the kind of protection that is necessary. Also, I think with respect to victims, it will depend obviously on the laws and the procedures that you have in Ukraine, but to the extent that victims can participate both as witnesses, but also as participants, if it's allowed under the law, for them to be engaged in the process and share their experiences and have their the injuries and suffering that they've experienced to be noted and to be understood by the court and the general populace. So I wanted to underline that because I feel that it's very important to ensure that victims and witnesses have participation to the extent that the law allows, but also they're the ultimate victims of the crimes that may have been occurred. And it is important for their participation, both for their engagement, but I think it's very important for the defense as well, to probe, to ask questions, and to have a full participation of the process. Mark, I don't want to take too much time. I know we're on a close clock. It's a real honor for me to be here today and with so many great international lawyers. We may have some issues about national processes versus international processes and that engagement. It's a very different situation on the international front in the international courts, but I think there's experience there that can be very useful. And I wanted to point in particular the victims and witnesses issues, but there's so many more. Thanks very much, and I'm glad to have questions and further discussions. Thanks, Mark.
David, thank you, and thank you for being here, and for the participants with questions coming in, we'll have a chance to come back to all of our panelists. As I mentioned at the start, what we will do now is to set out some outlines, guidelines on some of the substantive areas that we think are important when we talk about defending war criminals. And so each of our panelists will take roughly 10 minutes to set out these issues, these standards, and hopefully that will give you both insight, but also give you a chance to think about additional points and questions that you might have as we go through the event today. So Caroline is going to start off, and in the program, as you all receive, she will just talk generally about the introduction of the war crimes and crimes against humanity. We selected those because domestically, those will undoubtedly be the two main crimes that Ukraine domestic war crimes courts or courts will focus on. So we thought it would be good to give you a sense from the international perspective on what exactly that means under international law. So Caroline's going to walk us through that, and then we'll move on. So Caroline.
Yes, thank you so much, and welcome everybody. I'm going to address indeed the elements that need to be proven in order to establish either war crimes or crimes against humanity. And it is important to note that before we even get to the actual crimes that an individual can be charged with, there's a number of chapeau elements, we call it. It's elements that are part of the war crimes or crimes against humanity that need to be established first. And if they cannot be established, then a crime can only be charged under domestic penal law. Starting with war crimes, it is important then to distinguish between crimes of wars of an international nature and wars of a non-international nature. If you look at the situation in Ukraine, it seems maybe quite obvious that at least since February 2022, there's two states involved in this war. We've got the Russian army directly involved, and we've got the Ukrainian army directly involved. This is necessary to establish an international armed conflict, that there's more than one state force that is involved. But outside this scope of what Russia has called a special operation, that itself has no relevance to the qualification of the war. But there's other areas that are a little, maybe less obvious. We have some warring parties in Ukraine that could be seen as allies to Russia, the Ukrainian or the Russian-speaking armed groups. But it always has to be established that their acts are then under the effective control, the overall control of an actual state, being Russia. And for that, it's not important to show that Russia has provided financial support or military support. It needs to go further. There needs to be an actual involvement in planning and organizing the actual conduct of war. Just to sort of be aware, because if it's an international armed conflict, we have different rules that apply than for a non-international armed conflict. And once we have established there is a conflict, an armed conflict, international or non-international, it's when international humanitarian law applies. This can be found predominantly in the 4 Geneva Conventions. There's also customary international law and Hague Conventions, but when we look at the Rome Statute, which is essentially the main instrument to be discussed today, it's mainly reliance on the 4 Geneva Conventions. So when the international humanitarian law applies, these conventions regulate the conduct of war. It's also important that the actual legality or illegality of the actual attack itself that started the launch of the war is irrelevant to this question. That would be a different crime, the crime of aggression, which, as I'm sure everyone is probably aware, that's still not punishable under the Rome Statute. There is a definition, and maybe in the future that could become a punishable act. But for now, all that is relevant, that legal or illegal, the war is there, and then both parties or can equally be liable for war crimes. So there it's irrelevant who started the war. It's really looking at the situation on the ground. It's also important to establish a nexus to the war. So the armed conflict, you need to establish, as I said, there needs to be 2 warring parties at a minimum. For international, it needs to be more than 1 state. For domestic, it can be an armed group against a state, as long as there is a sufficient level of organization of that armed group. And there needs to be a sufficient level of intensity. Incidents of rioting, for instance, would not amount to a conflict under international law. So once that is established, you also, and when I say you, it's of course the prosecutor. The prosecutor must establish all these elements beyond a reasonable doubt. So if there is if they succeed in proving the conflict, then the second thing is the nexus. And for the nexus between the actual conduct of an alleged perpetrator and the war, it's important there is a sufficient relationship between the two. And only once you have established that, then you look at the actual awareness of the alleged perpetrator of the fact that he's involved in a war. So he must be, or he or she must be aware of the circumstances of the war, and must also be aware that his or her acts are part of that conflict. And I think that is important in this case, especially in the beginning. We've heard that some of the Russian soldiers, at least, were pretty clueless as to what they were getting themselves into. Then in terms of the actual acts that amount to war crimes, I will not go into all of them given the limited number of time, but I go into some that I think are the most important, and also the principles that need to be applied. And in this case, it will be particularly the military attacks. In general, it's not allowed to target civilians. Civilians are protected under the Geneva Conventions, and a legal act of war must be targeting a military objective. It can never be the civilians that are part of that intended attack. But what can happen is that civilian casualties, either killing or injury or destruction of civilian property, is what we would call collateral damage of what is a lawful attack otherwise. So when we look at the facts on the ground, we first have to establish, is the person killed, injured, or attacked, or the property, the house, the location, is it of a military nature or is it of a civilian nature? And that again depends very much on the circumstances. Something that is normally civilian can be military if it's used as such purpose. For instance, a house, when it is occupied by at least some of the armed forces, then that house loses its status of a civilian status. And the same could be true for a hospital. If the hospital is used for military ends, then that becomes then what you say a military target, a legitimate military target. That is important. Now, if that is established, and again, it's all for the prosecutor to establish if that is not the case, the defense doesn't have to prove that it's not a military target. They have to prove that it's not a military target. And once it's established that it's a military target, but there's a lot of civilian casualties, then we look at the rule of proportionality. Collateral damage is allowed when it's necessary, like it's the principle of military necessity applies, which allows one of the parties of a war to attack, to launch attacks that are necessary to bring the war to an end. But if the casualties are disproportionate to the actual military aim, then it can still amount to a war crime. But there is a wide range, at least to argue in courts. I think one case that is good for the defense is a case at the Yugoslav tribunal called Gotovina, where they also looked at the margin of error. If, for instance, you use an instrument that is like shelling, could be seen as an indiscriminate attack, But then they all really looked at the circumstances and found that in this case, the individuals were not guilty, because there is a margin of error that is allowed when you try to attack a military object, but then civilian casualties arise. So I think
Caroline, we have 2 minutes left.
Okay, so I think these are important principles to look at when you look at war crimes. Very briefly on crimes against humanity. Crimes against humanity do not need to have a link to a war, but they do need to be it needs to be an attack on a civilian population that is widespread or systematic. These are what we call the chapeau elements that need to be established again before we go into the actual acts. And there's also the requirement of awareness on the side of the individual. Again, there's some case law that is useful to look at in the ICC. I refer to the Bakbo case, where they took a very stringent approach to widespread. Incidents is insufficient. It has to be widespread. Systematic means it has to be pursuant to an organizational policy. And so it's not only the quality of the crimes or the quantity of the crimes, but there needs to be some consistency and a pattern, so to speak. If the prosecutor fails to show such a pattern of conduct, then it might be difficult to establish these crimes against humanity. And again, in a number of cases in the ICC, this has actually been a successful defense. I leave it here, given the time. I'm happy to answer any questions later on. Thank you so much.
Caroline, thanks very much. Obviously, as we talk about these issues today, we need to recognize that we could spend an entire week on each of these points. That's how challenging and at times complicated they are. But this will give us a sense on the interest of our Ukraine colleagues. And so as we continue to set forth some series of seminars, we can narrow in on the areas that you're most interested in. But Caroline, great to set those points out, particularly with war crimes and crimes against humanity. As I said, those are the two undoubtedly will be the focus for Ukrainian local domestic trials. David, Caroline has kind of set out some of these definitional issues, and of course the prosecutor's responsibility is to prove those cases, and Caroline has set out some of these issues that proof will have to be shown, but it does kind of open up opportunities for the defense to question and to counter some of these points. And I wondered if you could just begin to talk a little bit about this now as we transition into this crucial area of ensuring that defense does have effective representation. What role are the defense lawyers going to play now and should play in these national domestic tribunals as they do internationally as well?
Yes, well, thank you. I see from the agenda the three heads which I seek to address over the next 10 minutes. And as you've said, this would be a glancing blow, really, given the nature of the subject. First of all, I want to say this, dealing with the particular role of the defense lawyer in war crime trials. I am acutely aware of the very different world that I inhabit here, sitting in peaceful London, to the world that you Ukrainian lawyers are confronted with today. Now, I've represented several accused before international criminal courts, and all my cases, and indeed those of my colleagues, have concerned war crimes, crimes against humanity, genocide, whatever, that are quite distant from the temporal timeline of the conflict. And of course, they are held in international court. I've never had to deal with the situation that faces you. You are living in a country at war, with a ruthless aggressor who is responsible for war crimes committed on a systematic basis. And anyone with any doubts of that outside your country only has to pick up the OSCE report that came out a few weeks ago to see over 114 pages of detail there. And that's going to be followed up, as we know, by the UN report in just over a month's time. And I'm sure that's going to further detail these atrocities. And you yourselves would have experienced or been subjected to this situation. And you will have had family and colleagues and friends directly subjected to these atrocities. So for you to have to defend those charged with such crimes is clearly a challenge. And it may be met with disbelief and even scorn by some of your compatriots. But of course, I'm talking to lawyers, and as lawyers, we know that you can't have a fair trial where the accused is to be presumed innocent, but then deny that person legal advice and help. And we know as lawyers that fair trial is not a luxury. And indeed, it's a touchstone, really, for all that Ukraine stands for today: the rule of law and respect for the individual, concepts markedly absent in your opponent. Therefore, obviously, we all know that we have to have lawyers who are willing to represent those who are accused of these crimes and whatever they've been alleged to have done. Indeed, obviously, the more serious the offence, the more the need. Mark referred at the outset to the intervention of Richard Goldstone at the ICTY in the first trial, the Tadic trial. It was such a significant intervention supported by the IBA. At the time, the lawyers appointed to represent Mr. Tadic, that's Stephen Kay and Misha Vladimirov, didn't even have funding. They arrived and were self-funding the defense. The defense is easily overlooked, and it's essential in these cases, these complicated cases, that isn't the case. And as for fair trial, it's absolutely essential that the trials that are held in Ukraine are seen to be fair, or otherwise they just become a series of propaganda events, such as we've seen already in the Russian Federation and the so-called independent republics. Now, I'm not going to insult you by rehearsing what the international recognized elements are. You know that it's found in Article 6, the European Convention on Human Rights. It's set out in Article 67 of the International Criminal Court Statute as well, and it's contained in your own legislation. I know that there's been derogation with martial law from some of those elements, but of course it can't be wholly excluded. And in any event, that derogation is, I assume, going to be limited. What I'd say is this, that from my experience, and I believe this is shared by my colleagues, that while legislation and procedural rules provide the vehicle for a fair trial, only the defense lawyer will ensure that fair trial actually occurs. It's not the prosecutor who is essentially advancing his case for conviction. It's not the judges who are limited in their role. In practice, it is the defense lawyers who secure and are seen to secure fairness. And so we have to ensure that the defense lawyer is, well, obviously capable and trained and given access to those who can help and advise. I understand you are in the process of adopting legislation that reflects the ICC statute. And this is extensive and complicated law to digest. And we all need assistance from those who know more, who can bring more expertise than we individually may possess. We need access, and you need access to resources and expertise, such as provided by the IBA. There's a book, in fact, to which myself and the last speaker, Caroline Bisman, have contributed just one small chapter of 17 chapters. It's called Defense Perspectives on International Criminal Justice, published by the Cambridge Press. And it's a collection of 17 essays, all by defense practitioners, dealing with many of the difficulties and situations that you, within your own practice, are bound to come across. And I recommend that as a useful term, and we'll get you a copy and have it put in your faculty or wherever. It's in English, but I know many of you are very competent in that language. Obviously, the defense needs to be adequately funded. It also, that funding helps to underscore the importance of your role and the respect that the system within which you work gives you as defense advocates. You need to have the assets for trial management, an electronic court, for example, case map and such tools. You need to be capable of dealing with and having access to expert evidence on ballistics, armaments, DNA. You need access to other resources, informal and quasi-informal, such as Bellingcat. You need to have disclosure of material. This is always a problem. You need to be provided with all the necessary evidence and information, which may mean that you need to have access to confidential and perhaps secret material. You need a capacity to investigate the case. Now, I must confess in addressing you this afternoon that I am unclear as to the legal system in Ukraine. I've glanced at your criminal code and practice rules, and I understand you to have an adversarial system, but I'm not clear as to the extent of that system in comparison, for example, to the defense lawyer's role in my country, England, or in the United States, or in the hybrid court systems that we find at the Yugoslav and other international criminal tribunals and the International Criminal Court. So please bear that in mind. But within the adversarial system of the, for example, the International Criminal Court and the hybrid courts, the ability to investigate the circumstances of the crime, independent of the prosecutor, is probably the most important tool that I have had in conducting the defense in previous cases. Obvious difficulties confront you in doing that. I understand there's a discussion in Ukraine at the moment as to the appropriate forum for trials. I'm unclear what manner of court may be dealing with these cases. At the moment, I know it's the national court, maybe there'll be a national specialist court, maybe there'll be a specialist international tribunal, and there's also, of course, been the involvement of the ICC. But the elephant in the room here is the enormous difficulty presented by so many cases. 25,000 crimes, I understand, according to the statistics or the information that I read in my papers. I must say, international cases at the International Criminal Court, on average, one case would take 5 to 6 years. I think that must give us pause for thought as to the extent of that court's potential to be involved, albeit that it may, of course, deal with some particularly significant allegations. I know that the response on the Ukraine has, as your system permits, allows trials in absentia. I have a prejudice against that. I don't think any trial from a defense perspective can be fair absent the accused. They will always, I fear, be inadequate, and they will attract the inevitable criticism of perhaps just being propaganda, as we and I've referred to the trials that we know have taken place in the Russian Federation or are taking place in the republics. But on a final note, I'd say this: look, these crimes are not going to go away. War crimes of this nature inflicted on your people, they cast a very long shadow, a lifetime. And in that time, we know the world will change. And I have no doubt that the perpetrators of many of these crimes will have to face justice, even though they may not be available at the moment to stand trial. And Ukraine has a duty in international humanitarian law to investigate these cases. It's essential it does so adequately. And evidence and witness statements have to be taken now when memories are fresh. And there's a role, I think, for the defense lawyer in that process, even absent an accused. And you'll find a similar situation reflected in the International Criminal Court statutes at Article 56, I think it's D, where a defense lawyer can be appointed by the court, even though, or a lawyer can be appointed by the court, even though there hasn't been an arrest, in order to protect the future interests of the defense. Well, there we are. The intensity and scale of these crimes committed by and on behalf of the Russian Federation poses huge logistical problems. And I hope we can assist in some possible positive way. Thank you very much.
David, thank you very much for setting the groundwork and particularly what you said about it's the defense lawyer that really plays the essential role in ensuring that you have a fair trial. I think that causes us all to pause a bit and to reflect on how important the defense lawyer is. And of course, that then suggests that defense lawyers have to be quite robust in defending those accused of the crimes that are being committed now in Ukraine. And so I want to kind of shift over to Christy and Peter, because this gives us an opportunity to speak more specifically about grounds for really excluding criminal responsibility. So kind of being quite robust as defense attorneys in finding or looking at those elements that are essential to prove guilt, but if they're absent, then those are important points to bring up to ensure that the accused has the fair trial. So Christy, Peter, I'm going to hand it over to both of you as you walk us through some of these crucial points, in particular from the perspective of international law.
Thank you, Mark. I'm going to go first. Hi, everybody. I'm Peter Robinson. I'm sitting here in my home in the US, and I have to say I have no idea what it must be like for you in Ukraine. We still haven't recovered here from 9/11, and that was 2 buildings 20 years ago. I don't know how to express my empathy for you, but I do know how to defend war crimes cases. And so I hope that the experience that I have can be of some value to you today. I'm here to talk about the mental defenses, which means knowledge and intent, which has to be proven by the prosecution in every case, and which is fertile ground for defending individuals. In fact, probably of all the cases at the ICC and the ICTY and the ICTR, the Rwandan Tribunal, most of the acquittals have been based on the failure to prove all of the necessary mental elements, or what we lawyers like to call mens rea. Now look at, a soldier can't be convicted of killing a civilian if he reasonably believed that the victim was participating in hostilities. So even if you have an innocent civilian dead at the hands of a Russian soldier, that's not the end of the story. It has to be proven that the soldier reasonably believed that the person was not participating in hostilities. And participation in hostilities can be quite broad, including communications, providing logistics, material support. So there is a defense there, even when a soldier has killed a civilian. Likewise, a member of an artillery team can't be convicted of destroying civilian property if he reasonably believed that he was firing at a military target. So you can have a destruction of a civilian building, you can identify those who are responsible for its destruction, but unless you can show that they reasonably believed that they were firing against civilians, that person can't be convicted under the laws of war. Finally, a soldier who obeys an order from a superior and kills or injures a civilian can't be convicted unless he knew or should have known that the order was illegal. So again, you can have a dead civilian, you can identify the perpetrator, but if that perpetrator acted on the orders of a superior and it was not obvious that that was an illegal order, that perpetrator cannot be convicted. So that provides a lot of material for the defense to work with in defending someone who's charged with those crimes. Now that's the theory. What's the practice? Look at, your client tells you, I didn't know the person was a civilian. I didn't believe them to be a civilian. Nobody's going to believe them. You need corroboration. And that's the real job of the defense lawyer. You need to have interviewed the people who were privy to the orders, the communications, to try to obtain any recorded or written orders or communications that led up to the event. You need to be able to have access to open source material from social media, which perhaps shows the event happening in real time. All of those things are necessary in practice to defend somebody accused of war crimes. And simply relying on your client's word is essentially a recipe for a conviction and a sham trial. So you have to do all of that work, and it's hard. Preparation is 90% of performance. You can have the most eloquent orator, but if his file is empty, he's not going to succeed. You can have a bumbling fool, which maybe sometimes I am, yet if I'm well prepared, I can prevail. So that is what it takes to be a defense lawyer in war crimes trials. But it takes a lot more than that. It also takes courage. I'm going to tell you, I was a prosecutor in the United States for 10 years. During that time, my mother happily clipped out of the newspapers all of the reports whenever I was announcing someone's indictment or thanking the jury for convicting me in a case that I had tried. But then when I became a defense lawyer, she didn't talk about me much. Mostly she bragged about my brother who was in real estate and how much money he was making. For me, I was a good father. That was about it. So you'll feel that if you're defending people who are accused of crimes, especially heinous crimes like war crimes and crimes against humanity. You'll also feel what it's like to be a David in a fight against a Goliath, because the defense is always disadvantaged, not only in the perception of the job that you're doing, but in the resources you're given, in the amount of time you have to prepare, and in everything that happens in that courtroom. When the prosecutor does something wrong, it's a mistake. When the defense does something wrong, it's an offense. You have to be prepared for that, have a thick skin, and be courageous and have a lot of fortitude in doing that job. Well, that's all I'm going to say to you right now about mental defenses. I wish you all a lot of success. I hope that you'll undertake the defense of these accused with the same zeal and competence that you would bring to any other part of your work. And if you need my help, I'm ready to bring my slingshot and come and help you slay Goliath. Thank you.
Well, thank you so much, Peter. I hope everyone can hear me. I'm Kirsty Sutherland. I have the honor of being in the same chamber as Stephen Kay, and therefore I've heard a lot of war stories throughout my career about the exciting times at the ICTY and in the subsequent tribunals there. I practiced mainly myself in Cambodia and at the ICC, but I also did a lot of military cases here in the UK. Picking up from Peter's explanations, I'll be discussing some of the grounds that the Rome Statute provides for excluding criminal responsibility. Now, the Rome Statute identifies 4 main grounds. It is, of course, for the defense to raise these substantively. You will, as Peter's explained, you need to provide the evidence. You've got to do the legwork to get it. But it's still for the prosecution to prove its case beyond reasonable doubt. So in effect, you're raising it and then asking the prosecution to do the hard work of disproving it. So those 4 main identified grounds are mental illness, intoxication, self-defense, and duress. Mental illness. It might be that if in the case of somebody with very serious mental illness, you will be unable to obtain instructions. This may be familiar to you from your practices. In that case, you're going to have to consider how that impacts your ability to prepare any defense case. If they're severely unwell, you'll need to consider whether they're fit to plead or stand trial, and that's regardless of their mental state at the time of the alleged criminality. But the question for the court is the possible presence of a mental disease or defect and the effect of that on the accused's relevant mental capacities at the time of the relevant conduct. Insanity would be a complete defense, but lesser mental illnesses would perhaps arguably lead to diminished responsibility, which would be a partial defense that would be a matter for mitigation at sentencing. And for that, I would point you to the foundational case, Celebici, where they found that. But one of the things I think is important for the context that you're operating in is with soldiers, this can be a hidden thing, you know, a physical injury impacting the brain. Soldiers may very well have brain injuries resulting from physical blows to the head or even from repeated bomb blasts. To rely on anything like that at trial, you're going to need real medical assessment, medical reports by independent practitioners, not people treating the accused, but people who are able to provide a forensic report. The other thing that I've come across quite a lot in my work with military cases is combat fatigue, which is a sort of lesser form of post-traumatic stress disorder, and of course PTSD. So combatants on all sides of a war witness and experience deeply traumatizing events. They're pushed to the psychological limit, and they may well be mistreated within their own military. There are many reasons why people involved in a conflict, and you'll know this far better than I do, become severely traumatized, and this can certainly affect behavior. What you would need to consider is how that has impacted their ability to understand the events, their memories, and how they may well not even remember what happened to them and the way they were behaving. My own personal experience, I was part of a team representing a British Marine who shot an Afghan insurgent on the cold battlefield, and he was convicted of murder by a UK military court. That was later, after he was finally agreed to submit to psychological assessment, commuted to manslaughter. So the kind of evidence you need to think about here would be expert psychological evaluations and potentially experts on how trauma affects memory, and including that on how it affects judgment and behavior. It's been my experience that sometimes military personnel are very unwilling to undergo any such evaluation. Severely traumatized individuals may find the process too painful or find it difficult to trust medical professionals or why they're being evaluated, especially if they're being evaluated by personnel in an enemy country. I'm going to be quick on the rest of them, but intoxication. Now, obviously, voluntarily getting drunk or taking drugs and committing a serious crime is not tolerated under international law. But I think something that we need to consider is, were they drugged? Were they exposed to chemicals in the course of the fighting? And in this instance, it's, I think, important to remember that there's evidence of widespread use of Lariam impacting US military personnel and their mental state. Unlicensed experimental drugs were given to British soldiers in Iraq and in Afghanistan. They didn't know what the effects on their mental state would be. There are lots of instances in international cases of militias being given narcotics to encourage fighting. If a soldier is unaware that they were taking that medicine, unaware of the effects that they were having on them, or they were forced to take those drugs, or they were in a position where they were exposed to something that they weren't aware of, then that would be something for you to argue at court. Again, you'd need expert evidence to substantiate that, and you would need to be able to substantiate the claim that it was involuntary or coerced. Self-defense, I think that's fairly self-explanatory. That will be familiar to all lawyers. Where it's interesting in international law is that it also includes defense of property essential for survival or for the accomplishment of a military mission. It also has to be against an imminent and unlawful use of force, and the reaction has to be proportionate. But again, I think that's probably quite clear. Duress. This, under the Rome Statute, has three main elements. One, the duress has to be resulting from a threat of imminent death, meaning the threatened person is going to be killed immediately, or of continuing or imminent serious bodily harm to another person, meaning the threatened person is going to suffer serious bodily harm, again, immediately or in an ongoing manner. That essentially means that the potential future harm is insufficient, and abstract or probable danger just from an ongoing background of the conflict is also insufficient. Furthermore, the person would have to act necessarily and reasonably to avoid this threat. This is something that's been covered fairly extensively in the Ongwen case. So judges would have to consider what acts would have necessarily and reasonably been used to avoid the threat and what the accused should have done. And the last clause is that the person does not intend to cause a greater harm than the one they're seeking to avoid, and that is a subjective element. I don't want to labor this because I think we want to open up to the floor, but I want to just emphasize, as Peter was too humble, in all of this, there's extensive jurisprudence at the international level, and Peter himself has composed an incredible encyclopedia of bite-sized extracts, which I rely on heavily, where he goes through the relevant decisions organized by issues, and it's all openly available, in my experience, very up to date and fantastically useful. And I hope that he will be willing to share the links to those compendia.
Christy, thank you very much. Peter, thank you as well. These particular issues, sort of the more micro issues for the defense, are not only essential, but of course they could be somewhat complex. And so this may very well be an area later on that we want to come back to with the attorneys in Ukraine to expand on and spend considerable amount of time, because as Peter says, you could do that. Peter and Christy could be doing this for an entire week, I suspect, just in these areas, but they're absolutely essential as we kind of go to the robust area. So I want to thank the panelists, all of you, for setting out these crucial points. We've got questions that have come in, so I'm going to try to moderate this. Unless there's a question specific to a panelist, I'm just going to open it up and allow any of you to pick it up and just raise your hand as well. And I encourage our Ukrainian colleagues to send in further questions into the chat, and we'll try to get those to it. Let me just, there's a question that did come in about, Peter, you had mentioned about the kind of unless it's an illegal order in the sense of a soldier being told to shoot somebody. So the question is, well, how can an order to shoot a civilian not be an illegal order on the face of it? Why would there be any contention on this issue? What would the defense be able to show on that?
That's a good question, Mark, and thank you to the person who asked that, because sometimes it's not clear whether a person is a civilian or not. And so a commander can give an order thinking that a person is a combatant. For example, you can say, let's say that they observe a boy, maybe 18 years old, going back and forth between a building and the front lines. And they believe, or reasonably believe after doing their surveillance, that this person is supplying the troops. And so someone gives the order to a soldier and the soldier shoots that person. Maybe it turns out that that 18-year-old boy was just going looking for his father at the front lines, but they didn't know that. And it's not apparent that that was an illegal order when there was some reason to believe that the person was engaged in direct participation in hostilities. So that could be an example of how somebody could actually shoot somebody who is a civilian pursuant to an order and not be aware that that order is illegal. I hope that helps.
Thank you, Peter. A question came in, and this could be for anybody on the panel, but it deals with the issue of appeals and how that should be organized, and is that essential for Ukraine domestic legislation to ensure that there is a process of appeal? Who would like to take that question? Caroline, David, Tolbert, Caroline?
I can say just a few things on it. The right to appeal is incredibly important, and I think it's supported by the fact that many of the defendants before any of the international tribunals or the International Criminal Court were actually acquitted on appeal. So I think the actual, and also of course in domestic criminal law, this is essential. Like any human, judges make mistakes, and there's such a wide margin of appreciation because the facts are not set in stone. It's really circumstantial. You look at all the elements of the case before you issue a decision. So I think that there's need for an appeal is very important. Now, what kind of appeal? That's a second question, because you can have a limited appeal when it's only dealing, the court is only dealing with legal questions, or when there's a new circumstances or facts that are blatantly wrong, or you can have a wider appeal, like in many civil European countries where it's almost like a new trial. Now that might not be, if you give a very full trial in first instance, maybe to have a full appeal, that might not be necessary, but to have some level of appeal, I think is necessary. Thank you.
Any other additions on that? David, Tolbert, did you want to say something? I can't hear you. You're on mute. Sorry.
Oh, sorry. Was it me?
Oh, either one, either David.
Oh, yeah. No. Well, no. I've nothing really to add to what Caroline's just summarised. And again, it sort of reflects my ignorance of the Ukraine national system. I see that there's reference to the Court of Cassation, and I wonder if their system is presently one where appeals concern the facts at large, and there's basically a rehearing, as Caroline's just referred to, or whether it's, as we find with the hybrid courts, appeals only on error of law and error of fact, which has to be specified. I mean, bearing in mind the 25,000 crimes that are presently swishing around, as it were, in the prosecutor's office, then one would have thought the more expedited process was more appropriate, rather than, say, the Italian tertiary system with 3 courts dealing with almost complete rehearings.
One of the questions that had come in earlier, and maybe David Colbert, you could start and then have others add in. And the question was about ethical standards of behavior. So in defending the accused before the national Ukrainian courts, is there a priority? Is there a pattern? Is there a sense that lawyers have to abide by ethical standards? If so, what are they? We've talked about the need to be robust and to be somewhat aggressive as defense attorneys in defending the accused, but are your experience in setting out in the international courts ethical standards that might be helpful to our colleagues?
Thanks, Mark. I think it's a really important area, and it's one that we had to tackle to some extent in the international courts. Obviously, lawyers have obligations, ethical obligations under their bar association or their codes. We did end up developing some standards ourselves that we applied to defense counsel, but also to some extent to the prosecutors as well. And there was disciplinary action taken at the ICTY, and I think also in other courts, international courts. I'm not familiar with the Ukrainian standard, but it does seem to me that enforcing those standards is very important. And I do think we all have an obligation to ensure that those ethical standards are followed, and sometimes have to take the really difficult decision of even pushing these ethical standards and drawing the attention to the oversight. I'm not sure what the oversight would be in Ukraine, but certainly the higher courts, but also the Bar Association, I think plays a...
I think that, David, is interesting because we're partnering with the Ukrainian National Bar, and of course they are the regulatory bar of Ukraine. I remember cases in some of the international tribunals where the acts of a defense attorney were reported back to their national regulatory body, who then in turn held hearings against that attorney for breaking ethical standards. Is that generally common in the international courts that we've had?
It happens. I don't want to say it happens all the time, right, or imply that, but I recall making referrals back to the national bar, and I would think that that's important, because we cannot have lawyers not being governed by some system. And, the teeth of the international system can be fairly weak, and I think that's why it's so important to be able to refer it back to national authorities.
Peter?
Yeah, I would just like to say that as a defense lawyer, often your duty to your client comes into conflict with your duty to the court. And you often are placed in a position where the client would like you to do something, for example, raise an issue that you don't think is meritorious, and therefore you shouldn't be raising that issue. But at the same time, you want to fight hard for your client. And I think criminal defense, and in particular, if high-level war crimes defendants who have been leaders in military organizations or civilian political life, have their strong opinions as to how they should be defended. So to me, the most important thing for a defense lawyer is his or her credibility, because it's not the only time you go to that court. You'll be going there back time and time again, and your own credibility is critical to the success of your clients as well as your own reputation. So it's very important as a defense lawyer to be straight and ethical in everything you do, to explain to your clients and to win their confidence by fighting for them within the bounds of your ethical duties. And I can tell you from someone who has sometimes been in trouble for defending my clients that it's not an easy line to navigate, and it's something that you have to always be aware of. Thank you.
Peter, do you mind if I push you just a little bit on that?
Sure.
Where do you draw the line between, I mean, it may be useful for the council to hear your thoughts on, you know, where do you draw the line between the push from your client, let's say, versus the rules of the court, and particularly when it's vague? And I know that we run into these issues, and I was curious, and I thought it might be useful to hear a little bit more about what you've said.
Yeah, thank you, David. From my perspective, I try to interpret all of the laws and rules in the most favorable, credible way that they can be interpreted to my client. And so if a order is ambiguous and it can be faithfully and reasonably interpreted in a way that benefits my client, that's what I'm going to do. Sometimes if it's very close, I will maybe ask permission from the court first before I go and do that. But that's essentially the rudder that, as a defense lawyer, I use to guide my activities, that I want to obey all of the rules and all of the laws. And if they're ambiguous and can be reasonably interpreted in favor of my client, that's what I should do.
Thank you, Peter.
There's an interesting question that come in earlier that undoubtedly must be on the minds of Ukrainian lawyers who are being asked to defend accused for war crimes or crimes against aggression that we talked about, crimes against humanity that we talked about earlier. But what's the right of a lawyer generally, perhaps in your jurisdictions, to say, I simply don't want to do this. I will find myself in a very uncomfortable situation in society and my bands of friends. I simply don't want to do this, despite the very eloquent remarks made by Valentin, the need to defend the accused. But what right do lawyers have to generally say, I'm simply not going to do it?
Well, I can answer from the United States. I think it's different in the UK, perhaps. Maybe Hooper can speak after I, but in the United States, you are, as a lawyer, free to decline representation if you don't think that you could effectively represent the accused, given your own strong feelings or other circumstances which make you believe that you wouldn't be an effective advocate for that client. So, for example, there are lawyers who will not defend people in drug cases. There are lawyers who will not defend people for child molestation cases. And that's seen in the US to be perfectly acceptable, that when you're encouraged to take on the representation of criminal cases, but when your own personal circumstances make it such that you would not be an effective advocate for that person, you're allowed to decline the representation. Thank you.
David, Hooper, on your side in UK?
Yeah, it's it's slightly different. And of course, the reality doesn't always follow the rule, but we have a basic rule called the cab rank, taxi rank rule. And that is anyone who gets into your taxi or cab, well, you'll have to drive them to where they want to go. And that's the analogy that we have, that if you have the necessary competence to represent someone who comes to you for that help, then you should not deny them that. Having said that, I do know of people who have said, at least as it were within their offices, that they won't represent someone accused of a rape, for example. And I've always felt that that was wrong, that they shouldn't exclude anyone. On the other hand, I suppose if you're the accused person, you wouldn't want someone to represent you who was reluctant to do so.
Okay. I want to ask, there's a question that came in just a few minutes ago, and it relates to one that came in earlier, and it comes back to the ICC. There's been a lot of discussion, of course, in the press, and I'm sure within Ukraine about the ratification of the Rome Statute. It was mentioned earlier on the panelists. Does that have if Ukraine does or does not ratify the Rome Statute, does that have any real effect on the current situation of investigating and holding to account those that are accused of these atrocity crimes? So that's question one. Added to this, the question that came in about damage to property damage, destruction, and we know that we can see in the press significant damaging to businesses, whether it's shopping centers, entertainment complex, etc. What role, or the question was, can they be victims of the ICC within the ICC? And I'll just add, if not, is there a separate process that one would use domestically to ensure that these individuals, they view themselves as victims, obviously, are also compensated in some way? So that's a two-part question. Who wants to tackle that? Caroline, you want to take a crack at the first one on the ratification?
Yes, and ultimately, of course, this depends on Ukraine, but I would imagine if the law is implemented, then I'm not sure, I'm not familiar with the rules of legal aid in Ukraine, and if all these cases are at the moment being done on legal aid, most of the clients will not have enormous resources, but that, again, I'm not familiar with these particular situations. But if it's legal aid, and if there is actually a law implemented into Ukraine allowing prosecution specifically for war crimes and crimes against humanity, then that's likely going to incur more funds for the defense. At least if it's like in my country, in the Netherlands, when the case is more complex, then in exceptional cases, I might be able to get more funds from the state to investigate. So that, again, it's a question for Ukraine, but I think in terms of getting the greater means, I would imagine it really helps. It also accurately reflects the crimes as at least allegedly they are. And otherwise you have to like look for domestic crimes. Not sure what the situation is right now in Ukraine. So in terms of like war crimes, they probably have that already recognized. Crimes against humanity, likely not, but that's something that I would like to hear from the other side. In terms of the second question, oh yeah, again, I mean, I think it's a great idea. In a lot of countries, there is legal compensation for those who are considered victims. It's a question of funds. And then there could be a way, and it can be full participation like it is in many civil law countries, also in the ICC, but there can also be a separate court once, and this would be actually, I think many defense counsel would prefer that that option, because it sort of keeps it out of the question of guilt. But that at least once there is a finding of guilt, then there's going to be determination of appropriate compensation by another court.
David Tolbert, you want to add on that? Or?
Yeah, I'm pretty much in line with those comments. But I think there are a couple of steps, obviously, if the ICC, if the Rome Statute does, if it's taken up by the Ukrainians, and if that were to happen, that's going to change the landscape pretty significantly. But this is not an easy process necessarily. First of all, you'll have to ratify the Rome Statute, but then you'll have a knock-on effect of the law in Ukraine, because you will change the, probably change the rules and the regulations in Lebanon and Ukraine, and you'll have to have a major review adopting new legislation as well. So I think the ratification of the Rome Statute would be a very positive step for both for accountability and also the credibility of the work done in Ukraine. But it does seem to me that there's a big challenge that if you want to ratify the Rome Statute now, when you're in the midst of having trials already going forward or beginning to go forward, I think that would take a good bit of planning and thinking through the national jurisdiction and how it will be impacted on the Rome Statute, how the Rome Statute would affect that, and how would you make those changes? And obviously, you have to go through a political process, I think, to ratify. So, in theory, it's a very good idea, something that I think most of us would like to see that. But there are a lot of technical issues that I think could be involved in that.
I think that's an important point to make, because I think the perception probably is certainly outside Ukraine and perhaps even inside Ukraine. Well, why wouldn't you? Why wouldn't Ukraine ratify the Rome Statute? The ICC already has jurisdiction, as we all know. So it doesn't seem to be any apparent hurdles on why you wouldn't go for it. But as you've just described, David, there are some technical issues that can be a bit more complex, and those would have to be dealt with. So I know we're coming to an end here, and I wanted to end with a question to the panel that's come in that I thought was really kind of brings us full circle because of what we talked about at the start, what David Hooper had mentioned, what Valentin had mentioned about, well, society within Ukraine as well will certainly understand that if a lawyer, this is a question, that a lawyer is there simply to monitor kind of procedural violations on part of the court. But it becomes very different if the role of the lawyer is seen as being, as I've used the term, robust in defending the accused. So getting back to that initial point, what's the message for Ukraine, the population of Ukraine, for the important role that defense lawyers play beyond the monitoring procedural issues, but actually being very robust in bringing defense to the accused. Who would like to start with that? I'm gonna be calling on a couple of you. So David Hooper, I'm gonna ask you to say a few words on that, and I'm gonna ask some others to do the same. So kind of bringing it a full circle. Questions brings us back to this issue of, boy, we've got to, we place ourselves in a real situation of having to be aggressive and robust, but the Ukrainian population generally may just be looking for us simply to monitor, and they accept that, but to go a step further is difficult.
Yeah. Well, as I said, I'm happily sat here in quiet London, and I'm not sitting in an office in Ukraine with the potential of having to represent someone who's part of the process of inflicting all this hurt on my country, on Ukraine. It's a very testing situation. As I say, I don't know of a case where there's ongoing international criminal war crimes trials actually happening as these activities are going on and around you and being inflicted on people. That said, I understand so far there's been a handful of cases where people have been charged with war crimes, Russian soldiers. Those cases have been dealt with, and indeed they're reviewed in the OCS document that I referred to earlier. And also the response that Ukraine has made to some of the mild criticisms, I should stress mild criticisms, that document contained in its findings. But as a defense lawyer, not there as a rubber stamp. If you're representing a Russian soldier who says that he didn't know that person was a civilian, or he thought that person was on the phone to give away Russian positions or whatever it might be, then those are the issues you're going to have to explore. And you're going to have to do it. And I don't know whether you have a specific code of conduct as defense lawyers. I assume you have. But if you're representing an accused, then you have to represent him fully and honestly and to the utmost of your ability. That's your duty, as you know. You have to do so, of course, in the context of being honest with the court. You mustn't mislead the court. So we know that what those parameters are. It's not an easy situation. Most of us who represent accused people, whether in our own national systems or in an international criminal court, find that we often work and live, as it were, not in shades of black and white, but in the grey areas. Also, we often find, despite the terrible crimes with which an accused that we represent is charged, that there's always a human connection, and that will play with you as well. I still remember when I first went out to represent someone charged with genocide at the Rwanda Tribunal. He was charged as a government minister with participating in the genocide of 800,000 people. I remember on the flight going to Tanzania, where he was detained, thinking to myself, my goodness, this would be like meeting Eichmann. I'm going to have to shake his hand. Will I shake his hand? But when I met him, the impression I got was very different to the one that I'd carried in my head. And I'm glad to say it was on the evidence that the judges found that the prosecution witnesses were lying. That wasn't my submission, that was their finding, and he was acquitted. So I think you must, as defense lawyers, step into this arena with your eyes wide open and obviously knowing you may be subject to criticism, but knowing that you have an important function to play and that at the end of it all, the trials that you participate in will be seen as fair trials, as Peter said, and as Mark said at the outset. And that's going to be the touchstone that people in the future are going to look back on. Were these trials fair? We know what they're like in the Russian Federation. We know what they're going to be like in the so-called republics, independent republics. And I firmly believe that that Ukraine, married as it is to the principle of rule and law, has to produce fair trials, and you have to do it.
David, thank you so much for those words. Last words to Christy on this issue, this question that came up. Your thoughts?
Oh, thanks, Mark. Yeah, I think we have a saying, you know, a prosecution is only as strong as the defense. And I have heard that a senior international judge once said that the true measure of the court lies in assessing its acquittals rather than its convictions. And I certainly think that the legitimacy of these prosecutions rely on the defense being strong, being real, and being taken seriously. And that is ultimately in the interests of the prosecutions themselves and therefore in Ukraine. And I think that it will really spell how Ukraine emerges from this conflict as the moral superior. And therefore the role of the defense is critical.
Christy, thank you. Peter, your thoughts on this?
Yeah, very briefly. I think the bar has a role to play in educating the public about the role of the defense lawyer in these cases. When I was in Rwanda, I saw they had a cartoon of a prisoner standing before a judge in his pink uniform, which is what they wear in Rwandan prisons. And the lawyer is standing next to him in his robe. And there's a bubble that says, the lawyer is only doing his job, he's not the criminal. And I think that kind of education helps to have the public understand the role of the defense counsel. And for each of you who are thinking about whether to participate in the defense of someone, I think that it helps to think of your role as really a beacon of light in your society. The person who kills a civilian or destroys a civilian building, he doesn't give due process to his victims, he just kills them. But you're better than that as a society. And so you will take the time to put that person on trial, to give them a lawyer, and to give them a fair trial. And the defense lawyer is the touchstone of that process. If you just monitor the trial, you're not doing your job and you're letting down the entire system. So I hope that those of you who participate in trials will do so with integrity and with vigor, and know that the job you're doing is really the Lord's work. Thank you.
Peter, thank you very much. Caroline.
Yes, thank you so much. I can only very much agree with what my colleagues have said, but in addition, I would like to say that one of the most important aspects for me of a defense counsel is to give a voice to the accused, even if we don't want to hear the voice. We still need to hear it. I think what is important is that the situation is complex and it's always more nuanced than it first seems. The defense is actually the only in the process, or at least the most interested in the fuller truth, so to speak, in also these aspects that would lead to question marks about someone's guilt. And especially when a conflict is so widely spoken about, when the media has already published about it and everyone has strong opinions, there is the real tendency and danger to make quick judgment calls on who is liable and who is not. And I think it's very important, we already discussed, that sometimes facts are not what they first appear. And that this is fully coming to the surface. And then it's for the judge to decide on the basis of the entire picture and not only of the prosecution picture. So I think the role of the defense counsel is of equal importance, actually. to the role of the prosecutor to have a just result at the end of it, and of course one that will stand the test of time. So I really hope that a lot of you will have the strength to do this and find it as exciting as we have found it, and that if you feel alone, you know that there's a whole international team around that would be in support, both morally and if needed, in any other way as well. Thank you so much, everyone. And oh yeah, there was one question in the, I saw one question addressed to me. I don't need to go into it, but I actually responded just now in the text. Thank you so much.
Thank you, Caroline, for doing that. And finally, last point, David Tolbert, right, hand it back.
Yeah. Well, thanks, Mark. I think this has been a really good discussion, and I want to thank everybody who's participated, both the experts, and it's good to have pretty good questions from the floor as well. I, of course, don't disagree with my colleagues. I think the only thing I would add is that we need to strengthen the whole system. It's, I think, frequently, probably in this case, it's quite right to work with and strengthen the Defense Council because given the situation, we want to ensure that justice prevails. But I think we also have to recognize the whole system needs to be strengthened, both from the court and probably from the prosecution side as well. There's probably reform is necessary on that front. So I think it's what we're doing today is very important. I've got a lot of respect for the colleagues who are taking on this tough task of representing those who are accused. And there are a lot of others who are working on other aspects of the judicial system. I think it's probably a good idea to be in touch with some of them. I know that I had some contact with folks in Ukraine, both locally and but more internationally. A number of groups are working on that. So I think these things need to be brought together, but I think this is really a great start on defense, because no doubt it is not only important, but probably not nearly enough supported at present. So I'm very pleased to be part of this, and I think that this is very impressed with our experts and good questions from the floor. So thanks a lot, Mark.
Great, David, you're welcome. So let me say this then, as we, I know we're running a little bit over time, but that was, I want to thank the panelists for participating. I hope this will not be the last. We're eager to hear from our colleagues areas that you would like to focus on in the future. So you'll, Salva, Valentin will hear from you, and we're here to provide whatever assistance we can. I think I can speak for all of us to say that, as members of this profession, all of us, we're just exceedingly proud to be here with you. You really do inspire us. You're going through an extraordinary, difficult time, and you're doing so in the very best way of our profession. And that's why the International Bar Association and all of us here are keen to continue to help in whatever way we can. And as I said from the start, we were here when this war started. We will continue to be here to support Ukraine in any way we can. So I want to thank all of you for taking the time to be with us, and I hope it's not the last time. So I'll turn this back over to Sava or Valentin for any last remarks. And thank you all again.
Thank you, Mark. Thank you, honorable speakers. It was a very interesting event for us. And of course, we will appreciate your support in a way of studying and teaching with us because we grew up together, and it's not just let's say our problem of our country. You see, it's a difficult topic to discuss. So I'd like to thank you all for your participation, and we will wait for new meetings, for new events, and we will support any movements, any discussions, and we would like to attend as many possible events because they are crucial for our country right now. So thank you very much, Mark. Thank you all staff of International Bar Association, because you did marvelous things to us. So one more time, thank you, Mark.
You're welcome, Sava. One thing I wanted to do, and maybe we'll send it to you, there was some request, David Hooper, on your book that came in. So we'll send that link. Sava, I'll get that link to you, and then you can send it out to the participants for their interest. I'm glad that there was a desire to have that link, and David will be able to provide that for us. So,
yep, thank you very much.
Okay, thank you all. Stay safe, stay well, and we look forward to seeing you again soon. Thank you.